We continue working to break down the decision from Secretary of State Shanna Bellows that Donald Trump is not qualified to appear on Maine's primary ballot. New at noon today, our Sam Rogers spoke with Secretary Bellows just this morning, and we want you to hear how Bellows explained her decision was not a matter of partisan politics or personal beliefs, but one of state law.
It's important for Maine voters and the citizenry to understand how the process works here in our state, because every state controls elections. That's why we have different voting rights laws, different election laws. And Maine is unique. To my knowledge, we're the only state in the country where once a candidate is qualified for the ballot, which I did qualify Mr. Trump initially, any registered Maine voter can bring a challenge under Maine election law to the candidate's qualifications. I am then obligated by the law to hold what's called an administrative hearing. It places me in the role as an adjudicator, the administrative hearing officer, not an advocate. I must hear testimony from witnesses, hear evidence from both sides. They may be represented by attorneys, and in fact, Mr. Trump was represented by counsel, and so were the challengers. There were 5 challengers and 3 challenges, so Marianne Royal, Paul Gordon, and then 3 former state senators, 2 former Republican state senators, Kimberly Rosen and Thomas Saviello, and former Democratic state senator Ethan Strimling. So under the law, I held that hearing within 5 days of the challenge, which is my deadline to hold a hearing. And then similarly under the law, I must in fact issue a decision a week after the hearing process concludes. So after those final briefs were submitted, I then had 5 business days to issue my decision, which I did yesterday in compliance with my obligations.
There is another key part to this. Secretary Bellows put a hold on her decision until the matter can be decided by the Maine Superior Court if the Trump campaign appeals, which they say they plan to. She says the court has until January 17th to make its ruling, which would then allow time for the ballots to be printed in time for the March 5th primary. So again, this is all based on Section 3 of the 14th Amendment of the U.S. Constitution. It is known as the Insurrection Clause. This is exactly what the clause says. We'll break it down for you. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by vote of 2/3 of each house, remove such disability. This is the first time in history that this is being used to disqualify someone from appearing on the ballot for president. Lawsuits, as we've been reporting, have been filed in several states around the country so far. So far, Maine and Colorado barred Mr. Trump from primary ballots, while efforts in Michigan, Minnesota, and California failed. A case is still pending right now in Oregon. By the way, Secretary Bellows will join me live in studio tonight at 5 and 6 as we continue discussing her decision.